Federal High Court in Abuja has stopped the Central Bank of Nigeria from releasing monthly financial allocations from the Federation account to the Rivers State government. The court, among other things, held that the receipts and disbursements of monthly allocations since January this year by Governor Siminalayi Fubara have been unconstitutional. Arise correspondent Godfrey EJembi has more.
This is another aspect of the long-drawn legal battle between the Speaker of the Rivers State Assembly, Martin Samawole, on one hand, and the Governor, Siminalayi Fubara, on the other. By the face of it, the Governor has been dealt a big blow as the Federal High Court in Abuja ruled against releasing federal funds to Rivers State. A judge, Joyce Abdulmalik, held that the central bank was under obligation to ensure that the right thing was done before money from the Consolidated Revenue and Federation accounts are released to the beneficiaries. The judge said the December 13 presentation of the 2024 budget to a 4-member House of Assembly was unlawful. The judge further held that the judgment of the Rivers State High Court, which gave power to the governor to implement the 2024 budget, had also been set aside by the Court of Appeal on October 10th. The judge therefore restrained the CBN, the Accountant General of the Federation, and 2 commercial banks from further allowing Fubara access money from the Consolidated Revenue and Federation account.
No money shall be appropriated without an appropriated bill being passed by the House of Assembly. It is very clear from the judgment of Motosho, which was confirmed by the Court of Appeal, that the budget was not properly passed. And in a situation like that, if it's not passed within 6 months, a state is not supposed to collect revenue from a consolidated fund. That is the issue of lawyers. That is the extant provision of the law. And that's what the court has confirmed today, that the Rivers State government has not complied with the requirement of the Constitution on appropriation of bills for expenditures and all the things that they need to do in the state government. It's a very clear judgment. And then also looking at all the other judgments that have been passed in respect of the Rivers State government.
Meanwhile, Fubara's legal team, after the judgment, immediately appealed the Federal High Court decision. Godfrey EJembi, Arise News.
Joining us now on the show is Okere Kingdom Namdi, convener, Lawyers in Defense of Democracy and Human Rights. He's joined by Abba EJembi, a lawyer and former FCT liaison officer of the Civil Liberties Organization, CLO. EJembi is currently the Deputy National Secretary of Middle Belt Forum, MBF. Good morning and welcome to the morning show, Mr. Abba EJembi. I trust that Mr. Kingdom Okere will be joining us very shortly. And also we have Rufai, of course, from Riyadh, Saudi Arabia, in on this interview. So I'll just go straight in. I mean, one of the things that Godfrey in that report had said was that the judge, Justice Abdul Malik, in her ruling had said that the governor hadn't put proper things in place before spending allocations, hence part of her reasons for that decision. We've had this conversation since the debacle in the Rivers State House of Assembly with the defection of some of the members of the House, majority of the members of the House, and then only 4 remaining, the vacation of seats, the presentation of the budget, the illegality or legality of it. And I'd like you to just break it down for us, because that's part of the crux of the issue, that the budget wasn't properly passed. It was only passed by 4 members of the House. That debate still exists. To set the foundation for this conversation, can you, from a legal point of view, give us your take on this? Was that an illegal, unconstitutional move by the governor to pass or to present the budget to only 4 members of the House, and it passed by only 4 of them, and he's operating since then?
Thank you very much, and good morning, Nigerians. To have a proper understanding of what is going on is to also understand that what has happened in the Rivers State House of Assembly was never within the contemplation of the framers of our Constitution. For 20 members of a State House of Assembly to lose their seat by virtue of their decamping from the political party that sponsored their election without there being a schism, a division in that party, I don't think it was within the contemplation of the framers of our Constitution. And so but of course, the framers of the Constitution had within contemplation that it was possible for a member to leave his political party without there being a division. Also, it is also possible to leave because there's a division, a schism in the political party that sponsored. They have made provisions for this. And because each member of the House of Assembly must be treated as individual members, the fact that 24 of them decamped, which I say might not have been within the contemplation of the framers of our Constitution, does not mean that the framers of the Constitution did not have in contemplation the fact that an individual member could decamp without there being a schism. I made ample provisions for this, that if a member of the House of Assembly decamped without there being a division within his party, and that division, of course, must be at the national level, it's not a question of the state. This has been decided in a plethora of cases already. It's settled. And therefore, the 24 members who decamped, it has been argued, had lost their seat by operation of the Constitution. Now, that matter has not been settled. The recent decision of the Court of Appeal has been also appealed to the ultimate court, the Supreme Court. And therefore, until we get a pronouncement from the Supreme Court, it is still not a point that has been settled. And that is why people have argued that the Federal High Court sitting in Abuja yesterday ought to have paused whatever it was doing to await the outcome of that decision from the Supreme Court as to the legality or otherwise of the decamping of these people and the placement of the budget by Governor Sim Fubara before the 4 members who are, people have argued, are the only cognizable members of the House of Assembly as at today. But of course, there is a decision of the court. And for me, that is what is important. The law is what is. It's not what ought to be, if you may wish to argue. It is the pronouncement of the court that is the law. And therefore, the decision yesterday from the Federal High Court is the decision, is the position of the law as at today. However, is that decision final? No, it is not. And as it is reported, the appropriate step has been taken by the lawyers to the government of Rivers State, which is to file an appeal. And I won't be surprised if this morning they are also filing a motion to stay the execution of this judgment, which for me will be a key step. And the outcome, the decision, the ruling that will emanate from such an application before the Federal High Court will be instructive. Whether the Federal High Court will want to look at the balance of convenience, which is to put the people of Rivers State at risk, in harm's way. Which balance of convenience is normally one of the determinant factors whether a stay of execution will be granted or not. If you can hear me.
Okay.
Yes. Yes, I can hear you.
Me. Let's dial back a bit. I get your point about legality of issues, that once the lawmakers decamped in the first place, that they should have gone. But the court has not taken a decision on that. I also want you to go back to the early 2000s judgment that says, which was in favor of the governor of Lagos, said, where the Supreme Court said expressly that you cannot, just give a unilateral judgment to withhold the allocation to a state. So taking into cognizance there, is it a case of many wrongs trying to make it right, in this case in Rivers as we speak today? Because like you said rightly, the court has not settled the case of the lawmakers at the camp, but also you are now seeing the court here trying to withhold the funds of the River State. That's one. Two, do you think you have the hands of Mr. Wike written in all of these matters as we speak today? And what will be the future of our judiciary in critical matters like this?
Thank you very much. Let me start from your reference to the decision in the AG Lagos State versus the AG Federation, which is the withholding of the funds of the Lagos State government in 2004 by President Obasanjo. Now, that decision, if you read that decision very carefully, you will see the holding of the court that the president could not, by administrative action, or executive action withhold the funds meant for Lagos State. And that if there was a dispute, the only appropriate forum for contending, for ventilating that dispute will be the courts, as created under Section 6 of the Constitution, particularly Section 6b. Now, the people who are doing this have studied that judgment very carefully. And because the powers, as determined by His Lordship, the CJN, as it then was Mohammed Uwais, that only the court could make that determination. They studied that decision very carefully, and rather than taking an administrative action or an executive action, have decided to approach the court. Whether this is right or wrong is a matter that will be settled by the courts ultimately. However, we should be very mindful. You talked about whether the judiciary, it will augur well for the judiciary. I think it's beyond the judiciary. What we are up against is the entire edifice called Nigeria. We need to be careful and look at our history. And Steve Fubara is of the People's Democratic Party, an opposition party. We are seeing a recap, a reenactment of what happened in the Western region, where the action group was in power, the opposition party, and there was a division, there was crisis, perhaps instigated by the party in power, which was the MPC. We saw how it spanned out from 1962 when Awolowo and other leaders of the party were convicted and sentenced and put in jail. And what eventually triggered all of this was this kind of situation. I think that we need to be careful and very mindful of the fact that what is happening in Rivers State has the capacity and propensity to degenerate this country into something else. I think it's beyond the judiciary. And I think that if the judiciary is mindful of this, of course the judiciary is not expected to embark on their decisions on the basis of media reportage. However, they do not live in isolation. They are part and parcel of the society. I believe that what is happening in Rivers State must be handled in a manner that we do not go the way of what happened between 62, 64, 65, and eventually what led to the coup of January 15, 1966. If we are guided by our history, by the fact that the political class cannot railroad this country into a situation where the entire edifice collapses on everybody, people should be. And the people who are in leadership today were not children as at 1966. They should know. They should know better. But I think that ultimately, I believe that the judiciary is going to do what is right. The decision, if it goes on appeal, we shall see whether the court of the Federal High Court can withhold, because another angle that must also be considered is whether this is not a dispute between the Rivers State government and the government of the Federation. And if that is the case, will the Federal High Court have original jurisdiction to dabble into it? Because withholding the allocation of a state cannot just be a matter between individuals. It is now the agency of the federal government, like the CBN, that is now being made not to release money, and the AGF. I believe that this, when it is ultimately considered, that the courts will make the right decision, and we are going to see a situation where that decision will ensure that our democracy is protected, not just in Rivers State. The implication of this, what is going on in Rivers State, is that the people are the ones who will suffer ultimately if you withhold the revenue meant for Rivers State. And I'm glad that the recent decision of the Supreme Court
So as you're making these points, a number of things are coming to mind. And you made the statement that this is now beyond the judiciary. However, we're in this situation because there was an intermediary who came to attempt to settle these affairs. And that, of course, was the president, who brought all parties to the table. And there was a peace resolution that was proposed. And Governor Fubara abided to all of the terms on his side. And he's now saying that he has been ambushed because the other side of the deal are not agreeing and sticking to the terms that had been proposed in that peace settlement. So if the courts are not going to settle this matter, and you're saying they're bigger than the courts, if a political solution, which involves the president himself, has been unable to resolve this matter, then where do we find resolution for this matter? And can we truly believe that, this is truly just between Minister Wike, and Governor Fubara? Because it almost seems like there's a bigger play, a bigger power at force who is allowing all of this to continue going. Is it time for the president to step in?
I see the point you are making, and this is a call for statesmanship. It is no longer an attempt to play partisanship, because if the edifice collapses, it's not going to save anybody. It might include the presidency. It might question the very basis of our federation. And I believe that if that is put into contention, then it will affect everybody. I believe that the president must stand up, must rise to the occasion, must intervene. There is no time in any judicial process where you cannot resolve the matter amicably. Indeed, our laws encourage resolution, our laws encourage amicable settlement of issues, and it can be at any point in time. So a political solution will be key. Because if you are to do arid legalism, just apply the law as it is, you may just be tilting the apple cart, and no one knows whose horse is going to be God. I believe that the president must step up, and it's not just the president. All the statesmen in this country, and we have former presidents and former heads of states who are alive and well, they must step in. The National Council of State must step in and begin to ask questions. I don't think that this is a matter that can be restricted to just Sim Fubara and Governor Wike or the president, because ultimately, like I was making the allusion to what happened in the Western region, if the people are made to begin to suffer and they feel that this is an existential battle that they must fight, and the boys go back into the crease and begin to... Don't forget that the bulk of the revenue, more than 25% of the revenue of the Federation comes from the territory which is called River State. If they begin to tamper, if sabotage is allowed to come into play, we may just be dealing with something that's bigger than just the judiciary and even River State and Governor Wike or Governor Fubara. I think that people must stand up.
Thank you for making that statement, Mr. EJembi. I believe Mr. Kingdom Okere is here. Mr. Okere, you've possibly listened to the conversation thus far, and you know the background of the story. So I'd like to reiterate the question, the role of the judiciary, the role of the executive. Is it time for President Bola Ahmed Tinubu to step into the situation, especially because he faced, if not exactly the same situation, a similar situation where the state was at loggerheads with the federal during his tenure? Yes, people might argue that President Tinubu is not at loggerheads, obviously, overtly with the governor of River State. But when it comes to resource control, resource allocation, he has a role to play. What's your take on this?
Well, thank you. Good morning, Nigerians. I've listened very rapt, to the very informed discussion of your guest, and the issue of political solution cannot be overemphasized. Not only political solutions too, from the angle of Mr. President, which he had previously attempted. I think also the Chief Justice of Nigeria, who is the chairman of National Judicial Council, should also step in, and look critically into what is actually happening at the Federal High Court, by way of finding, amicable, whether political solution, to the issues. Like the previous, the other guy said, a matter that is still sub judice, a matter that has not reached the ultimate court in the land, the apex court, a matter that all the issues in contention as to which faction of the River State House of Assembly is the authentic House of Assembly, they are still subject to litigation. And the Honorable Judge of the Federal High Court believed that this matter is of so urgency and important that, the matter, in fact, at one of the sittings, the judge had to retire like 3 times, on break, and came back and almost sat till 5 o'clock in the evening. So we don't know what was the urgency. A matter that is properly before the Supreme Court. And in pages 7 and 8 of the judgment, it is very clear the judge relied on the judgment of Justice Omotosho and the recent appeal court judgment that recognized Amawele's faction of the Rivers State House Assembly. And that judgment of Honorable Justice Omotosho compared Fubara to represent the 2024 budget of the Rivers State House Assembly. So this thing is a purely political issue that should not punish the people of Rivers State. The poor women in the rural areas that are attending antenatal in various health centers, so they should all die, because there's no fund to fund the health sector in the state, because there is a Wike who is demigod in Rivers State, whom the people of Rivers State should put his picture in the sanctuary and worship every Sunday. So the issue of political solution must be looked into, and the Chief Justice of the Federation and the agency should also look into this matter. Why are all the matters of pro-Wike lawmakers having this kind of speedy hearing, and every application they bring before the Federal High Court, is granted and none is refused? The Chief Judge of the Federal High Court should, the activities of the Chief Judge of the Federal High Court and his team of pro-Wike lawmakers, should be critically examined by the NJC. We as lawyers in defense of democracy, we are making this call. It's a clarion call, in as much as a political solution is ideal. Here. So the fact remains that, hello? Hello, I said the fact remains that this matter is properly before I can hear you.
Okay, I'd like to come in here by asking that, is it not President Tinubu's solution that complicated the matter in the first place, where it was deemed that President Tinubu took sides in his initial agreement that they all went to sign in Aso Rock? So the question is, what political solutions are we talking about, since we have seen President Tinubu's solution already to take sides, with Mr. Wike in all of this? That's number one question. The second question in all of this is, then what should be the lot of the suffering people of Rivers, because two political gladiators are fighting? Because these two people, Wike and Fubara, can't seem to resolve their problem, which they have now taken to court, and it's not a fight to finish. Those are just the two questions. Mr. Kingdom, you can start with it, and I can get the other guests with the EJembi to also comment on it. Isn't it Tinubu's solution that complicated the matter?
Yes, the president attempted, to have the matter resolved politically, and like you said, the other party, that's the Wike party faction, did not, live up to the agreement, that was reached, before the presidency. So that is the issue of sense of commitment, and sense of dignity and honor, to resolving this issue. If you have gone before the president and reached an agreement, and thereafter you renege, to the terms of the agreement, it shows indiscipline. It shows that there's no sincere commitment, to resolve the disputes. And then it calls to fact that parties should take the honorable part, to allow peace, to reign in Rivers State, and to allow the government to run. So Wike is not omnipotent. It's not a demigod that should be worshipped by the people of Rivers State in their sanctuaries every Sunday. So if political solutions have settled, the matter, like I said, is properly before the court, and the Supreme Court of Nigeria is the highest court in the land. So I didn't see any reason why this same Federal High Court that gave a systematic order, that ran contrary to Section 8515 of the Electoral Act, that no court should, give an order or any ruling that should stop an election. This same Federal High Court of Wike, or team of pro-Wike justice of the Federal High Court, also made an order just a few weeks ago to tell the police not to perform its constitutional obligation, to safeguard life and properties of the people of Rivers State, because there is a Wike who is the god of Rivers State. So all this issue, points to the fact that things are falling apart, and your guest, here in the studio also pointed out, to the plethora of political crisis that led, to the collapse of the First Republic, and the Western region political crisis and all that. So if that is what the presidency is bringing, so the people will continue this democracy, we must sustain it together. Ironically, the president of the Federal Republic of Nigeria, however he became the president, is today the president, is the man in charge. This person has participated actively, in all segments, in all the pro-democratic struggle. So one wonders, how things are now falling apart under his watch. This is a man that insisted on rule of law, challenged the former president Obasanjo 20 years ago. Judgment was delivered by the Supreme Court and said that you cannot deny the state of statutory allocation. What do you want the people to do? What do you want the judiciary to do? Okay, hospitals should be closed down, pensioners should not earn their salary, the poor people, the people that need this government intervention are the people in the rural area, people that attend those antenatal primary health centers.
Absolutely.
So you want the entire system to collapse because there is a weekend. So what I'm saying is that if political solution cannot be reached, let the people take their destiny into their hands, and exactly that is what the people of Rivers State are doing.
Well, we do, of course, we just do hope that
of the law.
we maintain a state of law and order in Rivers State. And this question is open to both of you, but I'll start with you, Mr. EJembi. As Mr. Okere has already alluded to, and you touched on this earlier, is that, of course, this is a ruling that had been made by the Supreme Court in 2004. So there's a precedent that has been set. So many people are saying that it is unconstitutional for a federal high court to go against the precedent that has been set already by the Supreme Court. Now, given the context that this ruling is being considered as being unconstitutional by many people, where do we go from here? How do the people of Rivers State, the civil servants, the various projects going on, all the things that need finance, very briefly, how will they get paid? Because Governor Fubara yesterday said that nobody should worry, that he will pay his people today no matter what. How can, is there any way that this is possible?
Well,
No. Let me start by correcting. I have a duty to inform. What the decision in AG Lagos State and AG Federation said was that it was unconstitutional for President Obasanjo, by that letter that he wrote to the Minister of Finance, which then the Minister of State wrote to all the state governors, particularly Ebonyi, Katsina, Lagos, Nasarawa, and Niger State that had created local government area councils, that the president could not, by administrative or executive action, withhold. And like I pointed out earlier on, His Lordship Mohammed Uwe CJN, as he then was, who gave the judgment, the lead judge, right, the late judgment, said if there is a dispute, because what he said was that there was a dispute as to whether the local government area councils that have been created by Lagos State, the other states, the other 4 states reverted to status quo ante bellum. And then it was only Lagos State who went to court to challenge the constitutionality of this. Now, the distinction that was made by the Supreme Court in that decision was that the president could not, by administrative or executive action, withhold. That if there was a dispute, he had to approach the court that were created to adjudicate under Section 6 of the Constitution. Now, what they have done, and I pointed this earlier on in my submission, that they studied that decision, and rather than taking an administrative action, have decided to approach the court for a judicial action. Is that judicial action correct? Is it valid? That will be tested on appeal. Like it was reported, the appeal was filed, a notice of appeal was filed yesterday. I'm sure that by today, they are going to file a motion for stay of execution.
Okay, thank you. Mr. Kerry, please, in 30 seconds.
maybe I need to land on this before we go to Mr. Okere.
We don't have
believe,
time. Mr. Okere,
and the earlier question is that this is the time for statesmen to stand up. It's beyond the president. If the president has taken sides, there are statesmen. I call on General Gowon. I call on General Obasanjo. I call on General IBB. I call on General Abdul Salami. I call on President Goodluck Jonathan. I call on all well-meaning Nigerians. I call on Senate President David Mark. People must stand up and bring this matter to the attention of the president that he must act in a statesmanly manner.
Mr. Okere, please, very briefly, just 30 seconds remaining, please. Mr. Okere.
Okay. From what the second guest have said, we have to wait, for the Supreme Court to make pronouncement on this. I think that settles it. See, the recent judgment delivered by the Supreme Court on issue of local government autonomy, you see how the states are complying. There's local government election being held. So the Supreme Court, as a final court in the land, still has that integrity. And whatever final decision that comes from the Supreme Court is the law. Nobody changes it unless you appeal to the our Lord Almighty. So what I'm saying in essence is that the issue as to which faction of the two Rivers State House of Assembly is the authentic faction is still subject to litigation before the Supreme Court. The issue of arising from the judgment of Omotosho that Fubara should represent the 2024 budget, which the Court of Appeal upheld, is still before the Supreme Court, the final court in the land. So there was no need for the yesterday's judgment, but that haven't happened. All the parties, all the issues now should not go to the Supreme Court. The Supreme Court has the final say, and I'm telling you that it is the Supreme Court that will finally resolve the matter.
The Supreme Court has the final say, absolutely. Thank you so much for your time to you both, Mr. Kingdom Okere and of course, Mr. Abba EJembi. This matter is by no means concluded. Of course, it's still an ongoing, it's a developing story. I will bring more updates here on the morning show as well as the Rise TV, of course.